Hello, ladies and gentlemen, wherever you are, you're most welcome to my show once again. It has taken a little bit of time, a long time since I made a post on my YouTube channel, and today I'm back. And my topic today is Senzo Meyiwa Case. This is the second video that I'm making for Senzo Meyiwa Case. Just a little bit of a background. Senzo Meyiwa was a soccer player, football player, was a goalkeeper and a captain for South African football national team. So he was playing for Orlando Pirates. Okay, that's a South African soccer club. He was assassinated or killed or murdered, okay, at his girlfriend's house. Not necessarily his girlfriend's house, but at his girlfriend's mother's house where he visited. So this case has taken many twists and turns. It's one of the most interesting cases, especially in the legal fraternity on matters of law. There are new things that people, members of the legal fraternity all over the world, or lawyers, are observing, okay, and also people of interest are observing in this case. So this is my second video to comment on Senzo Meyiwa murder case, currently going on in South Africa, in Pretoria, okay, at Pretoria High Court. So this is basically what is happening there. So the current situation, okay, let me just greet all of you, okay, wherever you are. You say Dumelang Kunjan, how are you? Okay, Jambo Nzuri Yako, okay, yeah, everywhere where you are, I greet you today. Ça va, comme ça va, comment vas-tu? Okay, that French and everybody else, if you can understand whatever. Alright, thank you so much. Welcome to this show. And the topic actually that has brought me to comment on this, and I will be also referring to another podcast, YouTube podcast, okay, where one South African lawyer has made a very, very important, very significant comment to the same Senzo Meyiwa case, and I wanted to make a reference of that as well. Okay, okay, is Mr. Thobani. He was actually a lawyer for the defense, okay, but we don't know what happened, and he left the case, but he's still back in the same case. He said he's gonna make an application that will have an application into the same case, okay. So I will make a little reference to the same story, and I'll explain exactly what he's saying. But the topic of my topic today, what I want to say is about the suspects, the lies, okay, that suspects seem to be presenting in the court. It has been now a concern, a serious concern, especially on the social media. People have been commenting about the narrations that are coming from the lawyers of the suspects. The lawyer representing the suspects, Mr. Nkomezu, right? Okay, first of all, the suspects, especially suspect number, the first suspect and the second suspect, there are 5 suspects, right? 5 suspects, okay. But suspect number 1 and number 2 and number 3, they are represented by the same team, okay. They are represented by the same team of lawyers. Number 1, okay, number 1 and 2. Number 3 is represented by number 1 and 2. Number 1 and 2 and 3, they are represented by the same lawyers. Number 4 and number 5, they are represented by separate lawyers. So lawyer for number 1 and 2, okay, and number 3, right, Mr. Mgomezulu made a statement during the narration. He made narrations during the cross-examination where he was putting up, he was explaining right to the witnesses, okay, the stories that the suspects went through when they were arrested, okay, and they just the sense on how the stories go about. Many people have commented that they sound as lies, okay, they sound not practical, okay, in the current situation and how people have received, okay, the narrations from the lawyers, from the lawyer, that lawyer, okay, during the process examination, they sound so questionable. For example, he said that the suspect, one of the suspects, was, when he was arrested by the police, okay, reached to the extent, the police reached to the extent that they used, you know, a device that to shock him so as to, you know, confess, make confessions or admission to the case, or to reveal some things to the case. All right. So with the situation in South Africa as democracy, and that has been even made as a reference by the judge himself, okay, about the rights of suspects, even the comments from many experts and comments from the observers interested in the case, okay, people have said that that kind of thing cannot happen, okay, doesn't sound real, okay, it does not sound. So the question here that I want to address is, why would the suspects lie? Okay, so I want to explain why I think the suspects can lie. All right, you should bear in mind that the suspects, when they are arrested, they are put in the cells, okay, and at every stage the investigations are ongoing, and like a case of South Africa, there are crime intelligence organizations working with the state to establish the events that may have happened, okay, whenever there is a crime, okay, whenever there was a crime, and whenever the crime is taken like a case in this in the current scenario of Senzo Meyiwa, okay, we have to know that, for example, this case was being handled by the late Mabena, that was the investigator, all right, he died, okay, then he handed over, but they were working together with Gininda, what they call colonel, not colonel, but brigadier Gininda. That time he was a colonel, Gininda, all right. So basically, even the witnesses so far who have testified, even the police witnesses, have said it very clearly that this case was handled by the crime intelligence unit, all right, which was headed by Mabena, who died, and left the files to Gininda, okay, but they were working together, but obviously it's obvious that the files were all later taken over by Gininda, and they were informants, people, and they said Mabena was working directly with the informants, okay, people who were informing them about, usually they were the investigation team. What they do is they get information and they work on those information to see if they make sense or they don't make sense. They follow any lead, okay, they follow any lead. So you should know that there were many leads, but they had to follow the lead that makes sense, and they came up with breakthroughs to the extent that they had a credibility test of the witnesses to bring them in court, okay. When they reach a point of arresting, you see, the case took place in 2014, and this is the time that they established the case against these suspects was only 2020, okay. And we have heard that, for example, suspect number 1, okay, was linked to another crime, okay, which happened in KwaZulu-Natal at Nongoma. So why this Nongoma case is very crucial? It's because they had to place that suspect, okay, on the crime scene. And how was that going to be possible? They had to trail him. You see, what they call personal, even Advocate Thobani in the YouTube podcast, okay, made a reference to the same thing, that personal audit, okay, personal audit is kind of, you know, where they put a person on the ladder, all right, and the trail of that person, because there is something else they have noticed, all right, or there have been informants, okay, or reports about that person, and the crime intelligence unit cannot say everything about how they do their things. Okay, this is very important. They cannot reveal everything they do, but what is being presented in court has been established, okay, to be attested by them, okay, to be credible, more credible, okay, arguments that they are ready to argue. The state is ready to argue. So what I wanted to say that why are the suspects appearing to be, using their lawyer and is making statements or narrations that appear to be lies? Okay, why lying in court? Okay, this is what I want to explain. Okay, when the suspects are put in the cells, right, then they get lawyers, right? So the lawyers actually ask them to explain the whole story, right? But as humans, they cannot exactly say how the story went about. Okay, sometimes even they can admit. Okay, sometimes they can admit the case that yes, this case is true. All right, yes, but the lawyers are members of the court. But you must know that them also is business. On the other hand, so the lawyers actually represent the suspects. They are standing for the suspects. Okay, they are representing the suspects. You should understand that point. That is very, very important point. Okay, because those suspects are their clients. So, what is their benefit for them if the suspects lose the case? There will be no benefit for them. Okay, the suspects have to win the case. So, for the suspects to win the case, then whatever is happening there, when they meet the suspects, they basically have to understand the case, the story. After understanding the story, then they try to transcribe that story in what makes sense. Okay, because you should be mindful that the suspects will not stand like to explain the statements. They already made the statements. Okay, those statements. Now the lawyers are disputing those statements. Okay, even there was a recording that was made by magistrate Coroner. This magistrate was assigned. Okay, she was not part of the investigations. Okay, but she was assigned to take confessions as an independent person who has nothing to do with that case. All right, but after she took that case, and she was prudent enough to make even a recording of that, but it was the lawyers disputed it and asked the court to throw it away, that it must not be used, the recording must not be used. Okay, where the suspect number 2 actually was confessing and admitting carrying out the case, okay, carrying out the murder or whatever it is. We don't know what exactly he admitted or confessed there in the recording, but the lawyers fought so hard, okay, to get that recording out of the case. Okay, why? So that's the question. It's the same question that you can ask, or everyone can ask. Why is the lawyer, okay, narrating a story that appears to be a lie? So two questions that are so suspicious. Why is the lawyer narrating to the witnesses a storyline that appears to be a lie? Even a kid, even a child can know that this one can be a lie. It cannot be true. There's no way you can say the police they took the suspect to a place where it looked like it was a dumping bin, like a dump site, and they took out the suspect. They started pouring water and beating him. You see, the way people pass, what time was it? Was it at night or what? It was not. They say now. You can see that kind of sense historical doesn't seem like making sense at all. All right, but why would the lawyers narrate that story like that? Okay, it's because they are punching. Okay, they want to bring in an issue of human rights. Okay, which is enshrined in the Constitution of South Africa, as obtained at the attainment of democracy. You see. So they will punch that place so much, that point so much, to bring in the whole issue of human rights, okay, to the suspects, because the suspects are supposed or they deserve some rights. Okay, we heard that at the Advocate Mkomezu made also that I said a very suspicious assertion where he said the suspect went to change his clothes because he soiled himself. All right. So, and that narration was first time to come from him. It has never been written or said anywhere else, even in the statements. Okay, it was first time that came out from him that it was his instruction. So they call instructions, but it's not actually instructions. Sometimes what lawyers will do is to transcribe the story and try to iron it and streamline it to make sense. So they will tell the suspect that, you know what, your story, the presentation must be like this, like this. Your story, you must stick to this point. You must stick to this point. You can stick to this point. That can sound unethical or unprofessional, but that is the reality. The reality is different from how you and me, we can perceive it. Okay, that is solidly the reality. The transcriber. You remember when Advocate Tefo first came into to handle this case. Okay, you will call that what he came up with a story, a complete story about how Senzo Meyiwa was murdered. That Senzo Meyiwa was murdered by the people that were inside. Okay, in the house. Okay, and the murder was for this was about insurance money or what money or this. Okay, all those things, they came out that there was nothing like that after all. You see, there was nothing, not even a single of nothing like that. Okay, even the relationship between Senzo Meyiwa and his girlfriend was not so that deep. Okay, to reach at that extent. So I'm not judging, but what I'm saying that the lies that the suspects are promoting there in the court are actually ironed by the advocates themselves, because to them it's a benefit. There is a lot to lose if they lose that case, so they have to punch a point, the point that they think is a weak point from the state. Okay, so now the other point that I wanted to address is what Advocate Thobani himself said. He said that Advocate Thobani said that he is planning, okay, to mobilize some resources, okay, to write or to make up an application to the court, so that they can plan a case. They can be for the court to order or prosecution, a national prosecuting authority, NPA, to include the people who were in the house as also suspects. Okay, so what he's saying that is that all the suspects, the 5 of them, then they must include, okay, all the people who were in the house as suspects as well. So there will be suspect number 6, number 7, number 8, number 9 going up there. All right. So that is the suggestion. He's saying that this is a suggestion that is one put forward to make an application to court. Okay, and I think he said that he already approached the court, and the court said no, this is a wrong court. You must go to the criminal court. So he must make application to the criminal court. So they are the criminal court. They will order the National Prosecuting Authority to include the other suspects that he thinks are suspects. So in what he called Primafacie case. Sometimes they call it Primafacie case. Okay? What is a Primafacie case or Primafacie case? Primafacie case or Primafacie case is actually a case where a person can be charged based on the actions or lack of actions. Okay? For example, U.S. called an application for order. So he said that there was already a precedence in the political circles where a DA, political party, okay, applied to court to have someone else or Zuma or another person to be charged with Primafacie case. So, which means that in this case, a precedence, okay, when a precedence takes place, it means that it's already a law, okay, and the court will use the precedence, okay, to lay a charge, to approve a charge, an order to the National Prosecuting Authority, okay, to invite the people who were in the house as suspects as well. All right. So the first problem, like I said, all right, it will be another case because that court will also hear that application, okay, very well, and there will be a challenge to that application. So it will be a separate case. All right. Then the second challenge to that application, will be that the National Prosecuting Authority, okay, is not obliged, okay, to make that kind of order, to accept that kind of order, okay. It's not obliged. It's not by mandate that they can accept that kind of order, okay. And thirdly, the court where Mr. Thobani will make the application is not directly obliged, okay, to make that order to the National Prosecuting Authority, because he has to make that order like a criminal in the criminal court, okay. So it will be a separate case over. So it will be like we are going back, starting it again. That's the downside. It will be like this case is proceeding and we are going back again. Okay. And also he made a point where he said that one of the suspects, one of the witnesses was Zandile Khumalo, and Zandile Khumalo wrote a letter to the President Ramaphosa. Okay. In the letter, she said that the president must help the case to go fast. All right. And Advocate Thobani was actually arguing that maybe the president said no, I cannot interfere in the case like this. I cannot interfere, okay, in the management of justice, or I cannot interfere in the case. Meaning that what he said, he refused to interfere. Okay, so Advocate Thobani said that maybe he refused, but on the other side, maybe he secretly did not refuse, maybe interfered or whatever it is. But what I want to say is that the application or the letter that Zandile wrote to the president was not wrong, because she was only suggesting, okay, the president is the one who appoints, okay, or who approves, or who nominates people who can work at the High Court or who can work in the judiciary. They work together. The president is executive, and then the judiciary. There is also the president of the judiciary. All right. So he has the power, not necessarily to interfere in the management of any case, but he has administrative power that he can, the executive power. He has some executive power that he can interfere. He can make a suggestion, okay, to the judiciary on how to handle that case to move fast, because it's actually costing everyone a lot of money, including the state itself is spending a lot of money on that case. So he can, because he's the one who makes appointments on the senior people, okay, in the judiciary. So it's not to interfere. For example, there was a problem with the previous judge, okay, and that he was sick. Also, he had some indictment. You see that. So these are some cross-cutting issues that definitely, like a witness can make a suggestion, can suggest that perhaps we're asking this case must be made faster, because you remember there was a time that maybe 1 or 2 years where the case was postponed, that no, this case would be restarted, okay, next year. You see, these are some of the things that, so personally I think that letter had nothing to do with the interference in the court or in the management of justice. It had nothing to do with that. Okay, commenting as an independent person have nothing to do with the court itself, but commenting just an observer, an independent observer, it has nothing to do with that. In my own understanding, anyone can make a letter, can make that application writing to the senior person to say, may you help us to tell these people to make it faster. Okay, for example, it's the same like you can go to the supermarket and where you find that just a normal example, where you have been, the services that you have been offered, you are not satisfied. You can write a letter and complain to another authority. Okay, you are not necessarily interfering in how they work, but you are only complaining that, okay, I had these problems, this, all right. And it's the same way, okay, where a witness can write a letter to complain that no, there are so many delays in the case. Please, can we help us to put a proper team? That proper team, when you talk about proper team, it is the court, okay? Proper team at the court that will not allow adjournment or stoppages in the case, all right? Because they are not necessary, all right? Bear in mind that, in a criminal case, it's very difficult because if you talk about criminals or crime, those people committing crime, they're very clever. Okay, they had planned everything very well, so it's very difficult. Okay, so the crime intelligence team is getting information, trying to find credibility in that information, examining that information. So I don't think there is, if you understand in a sober mind, you will see that there shouldn't be any problem with how the case is going so far. Everything is in order. Now, talk about the same story, the same issue of the application of an order to have some of the suspects to be included, some of the witnesses to be included as suspects, some of the witnesses who were in the house. The house where Senzo Meyiwa was murdered, to be included as suspects. Okay, on the same topic. Okay, on the same topic. Like I said, the court, the prosecution authority may challenge. Okay, that is a fact. Okay, may challenge that for their own reasons because it will be delayed the case. Okay, because where you're saying that we should have new suspects, it means the case shall have to start again. You remember here there was another judge, and this is the second judge. When the second judge came, this case started again. This is the same reason why, okay, one witness, Zandi Kumar, had to write the president to say, may you help us to make the case faster. You see, it's simple. Okay, but then what Advocate Thobani is bringing in my opinion, okay, is bringing the case back, you see, because it will take the case back and then they have to start again. Where the new witness will come in, okay? I mean, new suspects. It means the whole case, all the evidence, every presentation that has happened is now and void. So what will happen is that we'll start again. Advocate Thobani explained there that, once this case is concluded, okay, even these people, once they are like indicted or they are found guilty or they are found not guilty, whatever it is, okay, it will be difficult for the prosecution authority, okay, to revive this case with new suspects, okay. And I want to sharply contrast with him. I don't agree with him because, all right, the National Prosecution Authority has got full jurisdiction to take anyone to court. So even if a person says, no, this case was already adjudged and some people were already found guilty, even if these people are found guilty, right? No problem. They're found guilty, okay? But it doesn't mean that this is the final number, okay? There will be laws that can be applied as well, okay? To bring any other person, okay, in the same case, okay? If that person is found to have played part in this particular case, it can be revived. It's the jurisdiction of the National Prosecuting Authority, the jurisdiction of the National Prosecuting Authority to prosecute anyone. You see, so that is the point. So to say this case was already finalized or was already what, that can be just a defense, okay? But it doesn't mean that if people present their defense, it doesn't mean that they cannot be prosecuted. They can still be prosecuted. You see, so even if the suspects are found innocent, okay, and the state decides to bring that case to revive it at a later stage with different suspects, okay, they would not say no, some people were found not guilty for this. No, the prosecution may go ahead. Why? Because the National Prosecuting Authority has got laws, rules, acts that mandate them, right, to prosecute anyone in the court of law. Okay, so this is very important point that I wanted to make. Okay, just to comment on the Senzo Meyiwa case, the current state, and in summary, like I said, why are the suspects using the lawyers to tell stories that appear to be lies? Okay, it's because the lawyers themselves, okay, they are actually ironing, okay, the stories of the suspects, okay, ironing it and inferring the suspect to say, hold on to this point, okay, if you want to survive, hold on to this point, punch this point very hard, okay, hold on to this argument. You see that that's why you see that the suspect will be stubborn too much, holding on to one point, okay, because it's actually a suggestion from the advocate to say, hold on this point, this is where you will actually get a reprieve, or you will get a safety, all right, they're like a safety boat, all right, hold on to this point. That's why you see that the issue of the rights of the suspect has been prominent, has been very, very serious there in the court on Senzo Meyiwa case. Thank you so much for watching my channel. See you later. Thank you so much. Bye bye.